Hello everyone, and welcome to the March 2026 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case law update is on the published Court of Appeals opinion that was issued on March 2nd, 2026 of Mary Free Bed Rehabilitation Hospital versus Esurance Property and Casualty Insurance Company and United Services Automobile Association. The second case we will discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on February 18, 2026, called Spectrum Health Hospitals Doing Business as Spectrum Health and Corewell Health and Spectrum Health Primary Care Partners versus Auto Owners Insurance Company. Lastly, we will focus our discussion on the trending topic of PIP litigation pertaining to the unlawful taking exclusion of MCL 500.3113 subsection A. For this, I will give a brief overview on the topic. There is also a related recent published Michigan Supreme Court decision that was issued on March 10, 2026 of Carlonda, Naishe, Swoope versus Citizens Insurance Company of the Midwest that I want to discuss. The first case we will talk about is the published Court of Appeals opinion issued on March 2nd, 2026 of Mary Free Bed Rehabilitation Hospital versus Esurance Property and Casualty Insurance Company and United Services Automobile Association. This case discusses a somewhat novel issue under the Michigan No-Fault Act post-reform as to whether an injured motorcyclist or their medical provider may recover PIP benefits from a lower priority insurer after exhausting the coverage limits of a higher priority insurer. The themes that are covered in the ruling include limited versus unlimited PIP coverage, priority rules under MCL 500.3114, and whether stacking across priority levels is permitted. In this case, the injured claimant was catastrophically injured as a motorcyclist in a motorcycle versus motor vehicle accident. Medical treatment exceeded $1.8 million. Plaintiff provider sued Esurance, who was the higher priority insurer of the involved motor vehicle, and USAA, the lower priority insurer, with a policy belonging to the motorcyclist's parents with unlimited PIP benefits. Esurance paid a portion of the medical expenses but denied further payment on the basis that its policy contained a $250,000 PIP medical benefits cap that had been exhausted. Plaintiff provider then sought additional reimbursement from USAA, which denied the claim on the ground that it was not liable as a lower priority insurer. Plaintiff provider filed suit against both Esurance and USAA, seeking unpaid PIP benefits. The trial court granted summary disposition in favor of both defendant insurers. Trial court concluded that Esurance's policy was validly limited to $250,000 and that the No-Fault Act did not permit recovery from a lower priority insurer once a higher priority insurer had provided coverage. Plaintiff provider appealed as of right. On appeal, the Court of Appeals affirmed the trial court's ruling with respect to Esurance, but reversed it as to USAA, remanding the case for further proceedings. With respect to Esurance, the court analyzed whether the insured had made an effective selection of limited PIP coverage under MCL 500.3107C. Although the court found that Esurance failed to demonstrate a, quote, effective selection, unquote, in strict compliance with statutory requirements, particularly with respect to electronic signature authentication, it nevertheless held that Esurance was entitled to a rebuttal presumption under MCL 500.3107C subsection 3 because the policy had been issued, premiums had been paid, and the premium structure corresponded to a $250,000 coverage level. The court determined that plaintiff provider failed to rebut this presumption and that the documentary evidence, including policy declarations and payment records, sufficiently established that the insured elected limited coverage. Accordingly, the court upheld the trial court's dismissal of claims against Esurance on the basis that its policy limits had been exhausted. The court then turned to the central novel issue of whether plaintiff provider could recover additional PIP benefits from USAA, the lower priority insurer. In interpreting MCL 500.3114 subsection 5, the court emphasized that the statute requires claimants to seek benefits in the following order of priority, but does not expressly prohibit proceeding to lower priority insurers if higher priority coverage is inadequate. The court reasoned that prior to the 2019 amendments, this issue rarely arose because PIP benefits were unlimited, making the identification of a single highest priority insurer sufficient. However, the 2019 reforms introduced the option for insureds to select limited or no PIP coverage, fundamentally altering the landscape and creating scenarios in which higher priority coverage may be insufficient to fully compensate injured persons. In light of this statutory evolution, the court concluded that the plain language of the priority statute permits claimants to continue down the priority list when necessary. The court found support for this interpretation in related statutory provisions, including MCL 500.3107C subsection 6, which contemplates recovery under multiple policies up to the highest available coverage limit, and MCL 500.3114 subsection 7, which governs aggregation of benefits among insurers within the same priority level, but does not restrict recovery across different levels of priority. The court also noted that the legislature's repeal of prior anti-stacking provisions signaled an intent to allow broader access to coverage where appropriate. The court further grounded its analysis in the remedial purpose of the No Fault Act, as articulated in cases such as Shavers v. Kelly, which emphasized that the statute is designed to ensure, quote, assured, adequate, and prompt, unquote, compensation for injured persons and should be liberally construed in their favor. The court rejected the argument that priority rules determine the existence of coverage, clarifying instead, consistent with the case of Dye versus Esurance, that priority merely dictates the order of payment among insurers, not the scope of available benefits. Ultimately, the Court of Appeals held that once Esurance's $250,000 policy limit was exhausted, plaintiff provider was entitled to seek additional PIP benefits from USAA's unlimited policy. The trial court therefore erred in granting summary disposition in favor of USAA. The court affirmed the dismissal of claims against Esurance, reversed the dismissal as to USAA, and remanded the matter for further proceedings. The impact of this decision is substantial. As a published opinion addressing an issue of first impression, it establishes that Michigan's no-fault priority scheme does not bar recovery from lower priority insurers when higher priority coverage is insufficient. The holding significantly impacts potential avenues of recovery for injured motorcyclists and medical providers, particularly in cases involving catastrophic injuries that exceed limited PIP caps. It also increases exposure for lower priority insurers and is likely to influence litigation strategy in multi-insurer PIP disputes going forward. The second case we will discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on February 18, 2026, called Spectrum Health Hospitals Doing Business as Spectrum Health and Corewell Health and Spectrum Health Primary Care Partners versus Auto Owners Insurance Company. This case centers on overdue PIP benefits, insurer delay, attorney fees, and jurisdiction, and it reinforces the statutory mandate that insurers must promptly pay benefits once reasonable proof of loss is received. This case arises from a May 14, 2023 motor vehicle accident in Grand Rapids involving a motorcycle operated by Aaron Brown and a vehicle driven by Leah Wolf, who was insured by defendant auto owners. Brown sustained significant injuries, including rib fractures, a scapular fracture, and a displaced clavicle requiring surgery, and he received treatment from plaintiff providers, Spectrum Health entities. Following the accident, questions arose regarding whether Brown had his own valid motorcycle insurance through Progressive. Although Brown initially indicated he was insured, and Progressive later confirmed that an active policy existed, auto owners sought further verification, including a declarations page. Despite receiving confirmation of coverage from Progressive in June 2023, auto owners delayed payment of medical bills submitted by plaintiffs, asserting that the claim remained under investigation. Because insurers of motor vehicles are generally first in priority to pay PIP benefits in motorcycle accidents under MCL 500.3114 subsection 5A, plaintiffs submitted Brown's medical bills totaling over $76,000 to auto owners. However, the insurer did not pay within the statutory timeframe. Plaintiffs ultimately filed suit in November 2023 to recover unpaid benefits. During litigation, plaintiffs obtained and provided documentation confirming Brown's active insurance policy, yet auto owners still delayed payment until July 2024. Plaintiff providers moved for summary disposition under MCR 2.116C10, arguing that there were no genuine issues of material fact and that they were entitled to unpaid benefits, penalty interest, and attorney fees due to the insurer's delay. Auto owners opposed the motion, arguing that its delay was reasonable because it needed to confirm coverage, and also contended that the circuit court lacked subject matter jurisdiction because the remaining unpaid amount had dropped below $25,000. The trial court granted summary disposition in favor of plaintiffs. It held that 1. The payments were overdue under MCL 500.3142 because they were not made within 30 days of receiving reasonable proof of loss. 2. The delay was unreasonable, entitling plaintiffs to attorney fees under MCL 500.3148, and 3, the court retained jurisdiction because the amount in controversy is determined at the time of filing, not based on later payments. The court awarded remaining benefits, penalty interest, and over $17,000 in attorney fees. On appeal, defendant challenged both the award of attorney fees and the trial court's jurisdiction. The Court of Appeals reviewed the matter de novo and affirmed in full. In analyzing the attorney fee issue, the court relied on MCL 500.3142 and MCL 500.3148, as well as key precedent including Moore v. Secura Insurance and Brown v. Homeowners Insurance Company. These authorities established a two-pronged test: 1, whether benefits were overdue, and 2, whether the insurer's refusal or delay was unreasonable. Once benefits are shown to be overdue, a presumption arises that the delay was unreasonable, shifting the burden to the insurer to justify its conduct. The court emphasized that the no-fault system is designed to ensure prompt payment of benefits, citing the case of Shavers v. Attorney General and Esurance Property and Casualty Insurance Company versus the Michigan Assigned Claims Plan, which underscore that insurers must pay first and resolve uncertainties later. The court concluded that auto owners' delay was unreasonable. The insurer had confirmation from Progressive in June 2023 that Brown's policy was active, and any conflicting information, such as Wolf's speculative statement, did not create a legitimate factual uncertainty. Moreover, even after receiving definitive documentation in March 2024, the insurer delayed payment for several additional months. The court rejected the insurer's argument that it was entitled to extend the statutory 30-day payment period to conduct its own investigation, relying on the case of Bronson Healthcare Group, Inc. versus Titan Insurance Company, which held that insurers are not permitted extra time beyond the statutory deadline to verify eligibility. Thus, the court held that the trial court properly found both that the benefits were overdue and that the delay was unreasonable, and it affirmed the award of attorney fees. With respect to the subject matter jurisdiction argument, the court found that plaintiffs initially alleged damages exceeding $76,000 in good faith. The trial court properly exercised jurisdiction, even though later payments reduced the remaining balance to a much smaller amount. In conclusion, the Court of Appeals affirmed the trial court's decision, holding that auto owners unreasonably delayed payment of PIP benefits in violation of the No-Fault Act, and was therefore liable for penalty, interest, and attorney fees. This ruling reinforces the strict obligation imposed on insurers to timely pay claims upon receipt of reasonable proof, and clarifies that ongoing investigation or administrative delay will not excuse non-payment. Additionally, the decision confirms that jurisdiction is fixed at the time of filing, preventing insurers from divesting circuit courts of jurisdiction through post-filing payments. I want to now focus our discussion on the trending topic of PIP litigation pertaining to the unlawful taking exclusion of MCL 500.3113 subsection A. First and foremost, MCL 500.3113 subsection A is a provision of the No-Fault Act that disqualifies a person from receiving PIP benefits under certain circumstances. In substance, the statute provides that a person is not entitled to PIP benefits for injuries arising from a motor vehicle accident if, at the time of the accident, the person was willingly operating or using a motor vehicle, the vehicle had been taken unlawfully, and the person knew or should have known that the vehicle was taken unlawfully. In practical terms, the statute focuses on how the person came into the possession of the vehicle, not simply whether they were driving it illegally. A claimant will be barred from benefits if they were using a vehicle they did not have legal authority to take, such as taking it without permission or in violation of the law, and they were aware, or reasonably should have been aware, of that lack of authority. Thus, MCL 500.3113 subsection A serves as a fraud and misconduct limitation within the no-fault system, preventing recovery of PIP benefits by individuals who are injured while knowingly using a vehicle that was wrongfully obtained. There is a recent published Michigan Supreme Court decision that was issued on March 10, 2026 of Carlonda, Naishe, Swoope versus Citizens Insurance Company of the Midwest that I wanted to bring up today. This case addresses the proper interpretation of the unlawful taking exclusion under Michigan's No-Fault Act, specifically MCL 500.3113 subsection A, and clarifies the circumstances under which an injured person is barred from recovering PIP benefits. The central theme of the court's ruling is the distinction between the unlawful taking of a motor vehicle and the unlawful operation of that vehicle, and which of these governs eligibility for PIP benefits. The court emphasized that the statutory bar applies only when a claimant was operating or using a vehicle that was, quote, taken unlawfully, unquote, and that this inquiry is distinct from whether the claimant was violating the law in the manner of operating that vehicle. This case arose after plaintiff was injured in a motor vehicle accident on October 27, 2020. The following day, plaintiff went to stay at a friend's home. The next morning, after receiving an urgent call that her mother was experiencing chest pain and emergency services had not yet arrived, plaintiff took her friend's vehicle without permission in order to quickly reach her mother. While driving to her mother's home, plaintiff was involved in another motor vehicle accident. At that time, plaintiff had neither a valid driver's license nor automobile insurance. After the accident, plaintiff sought PIP benefits through the Michigan Assigned Claims Plan, which assigned the claim to Citizens Insurance Company. Citizens denied the claim, asserting that plaintiff was barred from recovery under MCL 500.3113 subsection A because she had taken the vehicle unlawfully and lacked a reasonable basis to believe she had permission to use it. Plaintiff then sued, seeking recovery of PIP benefits. At the trial court level, citizens moved for summary disposition, arguing that plaintiff's conduct fell squarely within the statutory bar. The trial court denied the motion, finding that there were issues of fact. On appeal, however, the Michigan Court of Appeals reversed, concluding that plaintiff was ineligible for PIP benefits because there was no genuine issue of fact that she was unlawfully operating the vehicle, particularly in light of her lack of a valid driver's license. Michigan Supreme Court then granted leave to appeal and undertook a de novo review of both the summary disposition ruling and the interpretation of MCL 500.3113 subsection A. In doing so, the court focused on the statutory language, reiterating that the primary goal of statutory interpretation is to give effect to legislative intent as expressed in the text. The court explained that MCL 500.3113 subsection A bars recovery only if, at the time of the accident, the claimant was willingly operating or using a vehicle that was taken unlawfully and knew or should have known that it was taken unlawfully. The court emphasized that the phrase, quote, taken unlawfully, unquote, has been previously interpreted in its prior decisions, most notably Spectrum Health Hospitals versus Farm Bureau and Rambin versus Allstate Insurance Company. Those cases establish that a vehicle is taken unlawfully when possession is obtained contrary to Michigan law, including situations where a vehicle is used without the owner's permission, even if there was no intent to permanently deprive the owner of it. At the same time, Rambin clarified that the analysis may include a consideration of the driver's knowledge or intent, particularly where the driver claims a reasonable belief that they were entitled to use the vehicle. These precedents, the court explained, remain controlling because the legislature retained the phrase taken unlawfully when it amended the statute in 2014, thereby signaling its intent to preserve the established judicial interpretation of that language. The court further examined the Court of Appeals decisions such as Monaco versus Homeowners Insurance Company and Ahmed versus Tokyo Marine America Insurance Company, both of which addressed the amended statutory language. While agreeing that the amendments modified certain aspects of the statute, particularly by replacing a, quote, reasonable belief, unquote, safe harbor with a, quote, knew or should have known, unquote, standard, the court held that the fundamental inquiry remained unchanged, whether the vehicle was taken unlawfully. Critically, the Supreme Court rejected the reasoning employed by the Court of Appeals in this case. The lower court had focused on plaintiff's unlawful operation of the vehicle, specifically her lack of a valid driver's license, as the basis for denying benefits. While the Supreme Court held that this approach was legally incorrect because the statute does not bar recovery based on unlawful operation. Rather, the statute requires a distinct inquiry into how the claimant came into possession of the vehicle. The court emphasized that taking and operating are separate concepts, and that unlawful operation does not by itself establish an unlawful taking. The court concluded that the Court of Appeals misinterpreted MCL 500.3113 subsection A by conflating unlawful operation with an unlawful taking. Plaintiff's status as an unlicensed driver, while potentially unlawful, did not resolve whether she had unlawfully taken the vehicle within the meaning of the statute. Because the Court of Appeals applied the wrong legal standard, its decision could not stand versus the Supreme Court's opinion. The Supreme Court did not definitively resolve whether plaintiff's conduct constituted an unlawful taking. Instead, it noted that the Court of Appeals had failed to adequately address the insurer's alternative argument that the plaintiff took the vehicle without permission and therefore unlawfully. The court remanded the case to the Court of Appeals to determine whether a genuine issue of material fact exists on that question. In terms of its broader impact, the decision significantly narrowed the scope of the unlawful taking exclusion. It makes clear that insurers cannot deny PIP benefits solely on the basis that a claimant was operating a vehicle illegally, such as without a valid license. Instead, the focus must be on whether the claimant unlawfully obtained possession of the vehicle and whether they knew or should have known that the taking was unlawful. This distinction ensures a more precise and textually grounded application of the statute and will likely lead to more fact-specific inquiries in future cases involving the disputed permission or authority to use a vehicle. That concludes the March 2026 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.